The Supreme Court is currently in its annual recess, but looking ahead to its next term, which starts on the first Monday in October, the court will hear a major consolidated gun rights case that challenges laws that ban AR-15s and semi-automatic rifles. These are the weapons that are frequently used in mass shooting events. According to a 2026 Everytown for Gun Safety report, an assault weapon and a high-capacity magazine were involved in all 10 of the highest casualty mass shootings since 2016. Right now, there is no nationwide federal ban on assault weapons, but 11 states and the District of Columbia have laws in place that prohibit the purchase and possession of assault weapons. Illinois and Connecticut are among those jurisdictions, and indeed, it is the constitutionality of the laws in those two states that now sits before the court. Viramontes versus Cook County is a challenge to an Illinois law that prohibits AR-15s and similar semi-automatic rifles. Last year, an appeals court upheld the ban on that Illinois law. But a group of Cook County gun owners and gun rights groups asked the Supreme Court to take up this case, writing in their petition for certiorari that the appeals court decision was, quote, based on an interpretation of the Second Amendment that flagrantly distorts this court's precedent and makes a mockery of the amendment's text, history, and purposes. The Supreme Court decided in June to take up this case and to consolidate it with a similar one, Grant versus Higgins. That case is a challenge to Connecticut's ban on AR-15s, a 2013 law that was passed in the wake of the Sandy Hook school shooting in Newtown, Connecticut. 20 children and 6 adult staff members were murdered in that school by a shooter who used an AR-15 rifle. At the core of these consolidated cases is a singular question: whether the Second Amendment protects ownership of AR-15s and other similar rifles. Federal courts have repeatedly upheld state bans on these weapons, but the conservative supermajority of this current Supreme Court has in recent years ruled in favor of expanding gun rights. Notably, in 2022, the court struck down a New York concealed carry permitting regime. This year's case brings the hot-button issue of regulating semi-automatic weapons back into the national spotlight and before this court. And it all happens at a time when the United States has experienced at least 309 mass shootings in 2026 alone. That's according to the Gun Violence Archive. After a quick break, we are going to discuss the potential consequences of this case with constitutional lawyer and law professor Leah Lippman and Mark Barden, the co-founder of Sandy Hook Promise. That's up next. For more on the upcoming Supreme Court case on gun rights and gun safety, I'm now joined by Leah Lippman, law professor at the University of Michigan. She is also one of my co-hosts on the Strict Scrutiny podcast. She is also the best-selling author of Lawless: How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. Also with us is Mark Barden, co-founder of Sandy Hook Promise, a nonprofit dedicated to preventing gun violence. Mark started Sandy Hook Promise after his son Daniel was killed in the Sandy Hook elementary school shooting. Mark, you know all too well the kind of devastation that assault weapons can cause. What do our viewers need to understand about the possible impact on communities across the country if the Supreme Court overturns these state bans on assault rifles?
Well, thank you for having me on, Melissa. As you have pointed out already, folks who are intending on harming or killing a lot of people in a short amount of time choose the platform that was designed to do just that in a battlefield situation. So we've seen, and I know personally, the devastation that the semi-automatic rifle platform can wreak on a school or a community, large group of people. It happens over and over again. It is the weapon of choice for somebody who wants to carry something like that out. I think we should be clear about the fact that there seems to be a distorted narrative that, gun safety regulations, policies, and laws are also prohibiting folks' rights to own firearms, and they're not. Gun safety laws and policies can coexist with folks' right to own a firearm.
Right, Leah, this consolidated set of cases has really captured the attention of many Second Amendment enthusiasts. The Second Amendment, as you know, involves the right to keep and bear arms. What do we know from the court and their most recent rulings about how the justices are likely to respond to this challenge to bans on semi-automatic weapons?
Unfortunately, the Supreme Court, or at least the Republican appointees, has shown they have a ton of zeal for basically cannibalizing and eliminating common sense gun control regulation because they've adopted an interpretation of the Second Amendment that maintains firearms that didn't exist at the time the Second Amendment was ratified. Those are still constitutionally protected. And yet governments have to show that the regulation of those firearms that's used today resembles the kind of regulations that were applied to firearms that looked substantially different than firearms do today. That is, the government would have to show that it is regulating AR-15s in the same way that the governments regulated especially dangerous weapons that existed in the 1700s and 1800s, like, muskets or bayonets. And based on that logic, the court last term struck down 2 gun control regulations, one at the federal level and one at the state level. So I think it's very concerning that the court took up this particular case.
All right, Mark, your organization has been helping to write and pass gun safety legislation, working with Congress, including the successful passage of the Bipartisan Safer Communities Act in 2022. That was the first gun safety package that had gotten through Congress in nearly 3 decades. What is your experience like getting legislation through this Congress, and how has it changed since the Supreme Court has adopted this really muscular approach to the Second Amendment?
We have long worked since the inception of Sandy Hook Promise in the wake of the shooting that killed my son Daniel. Sandy Hook Promise has looked to identify what has been missing from this narrative, and are there ways to learn how to prevent this from happening? And a common theme that continues to emerge is there are always warning signs. And each warning sign represents an opportunity for folks who are trained in how to recognize those warning signs to tell a trusted adult and get somebody to the help that they need before it becomes a tragedy. And this is a common theme, and we can speak with legislators on both sides of the aisle. You just said it, it's in the name of that bill, the Bipartisan Safer Communities Act. It does all those things in a bipartisan way because we need to all come together and agree that regardless of your background or your political persuasion, we all agree that we want to protect our kids and we want to make our communities safer. The conversation shouldn't stop at what happens in the courts or in Congress. But I have wonderful relationships with legislators on both sides of the aisle in the federal government and several states across the country who agree that there are solutions that are available to us right now that can help us protect our children. Children should not be going to school wondering if they're going to be shot. Teachers should not have to be fearing. Parents should not have to be fearing if their kids are going to be shot. We know that it's preventable. We have tools already at our disposal to protect our kids, and we should be all working together across the aisle and across every other persuasion to do that, to protect our children.
Right, Leah, Mark has just alluded to the realpolitik of this. We have children who are learning how to deal with active shooter drills. Mass shootings are a fact of life here in the United States. Last term, the Supreme Court also took up a case. This was about a federal regulation on ghost guns. And although at oral argument, it seemed that some of the justices were ready to invalidate that regulation, ultimately, the court upheld it. And one of the things we noted in our podcast, Strict Scrutiny, was that in the intervening time between oral argument and the decision coming out, Luigi Mangione gunned down a healthcare CEO on the streets of Manhattan, and he used a ghost gun. That was one of the guns at issue in those regulations that ultimately were upheld. And it seemed like that real fact, that realpolitik, might have colored the justices' deliberations. Do you think that the reality that Mark has alluded to, the fact that school shootings and the use of AR-15s is so prevalent, will also shape the court's decision-making here?
I certainly hope so. And I think it's very important for organizations like Sandy Hook Promise and the others that are involved in this fight to continue to make the case to the public about the importance of eliminating such dangerous weapons from the hands of would-be mass shooters. But as a legal matter, the Republican appointees on the Supreme Court have unfortunately said that when they are analyzing the constitutionality of these laws, evidence empirical findings, those don't matter. What matters is the justices' take on history. The ghost gun case that you alluded to was actually the Supreme Court's interpretation of a federal law. That is, the court did not weigh in on the constitutionality of the federal law and federal regulation. So I very much hope that all of this evidence and the horrific casualties that have resulted from mass shootings carried out with automatic, semi-automatic rifles move the justices, and those facts should stay in the public narrative. But I am concerned that as a legal matter, the Republican appointees have basically said, we don't care about the empirics, the evidence, or the facts. What we care about is our, frankly, odd take on history.
Well, can we talk about that for a minute, Leah? I mean, the conservative justices who have voted to strike down these laws in the name of the Second Amendment all claim to be originalists, that they are just doing what the framers of the Second Amendment would have wanted. But as you mentioned earlier, semi-automatic weapons are a very modern day problem. James Madison did not go around toting an AR-15. How will the court square the reality of this very modern problem with the language of the Constitution and the context in which it was written?
They unfortunately don't really try to square that. As we've suggested, they adopt protections for firearms that didn't exist at the time of the founding, at the same time that they demand that the government show, well, there were regulations that were quite similar to modern gun control measures. But they have been, frankly, pretty selective in how they have applied this historical test. Because in some cases, including the one from last term, as well as the New York case you mentioned, they have required the government to come close to showing there was a historical twin for a gun control measure. That is, you have to show that an enacted law or regulation looks quite similar to the one being challenged. But then in another case, they suggested rough analogs, kind of parallels, those will do. And so it seems like the kind of historical analysis that the justices use depend on their underlying intuitions about their sympathy for the gun control measure. That's not exactly law-like, but it might give us some hope that they could be moved by the evidence and the public campaigns that show the dangerousness of these firearms, that maybe that would persuade the justices to adopt a more lenient historical analysis.
All right. Mark Barden, co-founder of Sandy Hook Promise, and Leah Lippman, professor of law at the University of Michigan and my co-host on the Strict Scrutiny podcast. Thanks so much for getting us up to date on this pressing case at the Supreme Court.